Same process if you receive a third-party subpoena. If your client isn't a party to litigation, but you receive a subpoena that you need to produce things, you kind of go through that same process. So ask your client about key factual issues, possible witnesses, and possible documents that he or she knows exist. And when I say document, I mean both paper and electronic. Use all of those sources to refine your time frame. For example, is there a statute of limitations? Key technology users and available technology sources. For all cases, plaintiffs, use the information from your investigation prior to filing suit to determine your time frame, your key issues, your documents and information, and your witnesses. If you didn't do an investigation before you filed a complaint, I've got a nice little rule for you. It's called Rule 11, and there are sanctions. So if you didn't do an investigation, then you're going to be in trouble with a lot of different people with nothing that has to do with e-discovery. But from now on, when you're investigating a case and deciding whether to file a complaint against someone, part of that investigation should include e-discovery. And not necessarily e-discovery in the sense of actual discovery, but it should encompass electronic information. For all cases, whether you represent the plaintiff or the defendant, define the scope of the data that you will seek and or produce early. If it's a federal case, you have to under Rule 16b and 26f. But in any case, you should be thinking about electronic data as early as possible because it is easy to get rid of. Although it's persistent, there are certain kinds of information, like text messages, that are easy to get rid of. And there's a huge scope of information. So the earlier that you think about the exact scope of what you're going to seek from the other party or what your client needs to produce, very helpful. Don't forget that your discussion about e-discovery under Rule 16b and 26f in the federal system, and I think relatively soon in almost all states, can be within weeks of complaint filing. And in fact, there were numerous cases that I handled. I did employment discrimination in other cases, so I was almost always in federal court. There was a lot of cases that I was involved in where I had to do my planning report, including the e-discovery discussion, before I had even filed my answer. So I didn't know what my affirmative defenses were going to be, but I knew what electronic evidence there was to support them. The scope of ESI for family law cases, it's a little easier. Just be conscientious of the scope, similar to how you would in traditional discovery. So the same thought processes that you went through for how am I going to seek photographs, how am I going to seek documents, is the same sort of thought process you need to go for family law cases with e-discovery. Think about the issues that are at stake. Divorce, is there a custody issue? What are your grounds for divorce? Just think about those issues, and that will help you to define your scope of electronically stored information. Also be cognizant of cost. And I know you will be, but one of the articles that had a lot of information that I used said, to decide whether to pursue electronic discovery, the lawyer should do a cost-benefit analysis. As the amount of money in dispute in the case increases, the analysis will tilt in favor of electronic discovery. Where the issue cannot be quantified in money, for example, child custody, it's not as easily subject to a cost-benefit analysis. The lawyer should also consider that pursuing electronic discovery may add to the emotional overlay of the case. In the same vein as that emotional drain that is accompanied with electronic discovery in matrimonial cases, the AML's Bounds of Advocacy suggests that reducing the emotional level of a family dispute is an appropriate goal for the lawyer. And then it says 1.3, an attorney should refuse to assist in vindictive conduct and should strive to lower the emotional level of a family dispute by treating all other participants with respect. 7.1 says, an attorney should strive to lower the emotional level of marital disputes by treating counsel and the parties with respect. That includes e-discovery. All right, so we talked about gathering information. We talked about the scope of electronically stored information. Step 3 is the litigation hold. This is your part. You're involved in step 1 and step 2, certainly, but this is the first really where the sanctions issue gets fired up. So you have to institute a litigation hold, either on your own client, so you're telling your client, hey, we're going to be involved in litigation, you need to save X, Y, and Z data. Or triggering the duty to preserve for the opponent. You can do that. You can trigger the duty to preserve on the other client, or on the opposing party. Remember that we talked about when the duty to preserve is triggered, and that demand letters could trigger that duty. That means you sending a demand letter to the other side could trigger their duty to preserve information. But once the client has the duty to preserve information, the lawyer has the parallel duty to institute an effective litigation hold. How do you do that? Well, for your client, you have to draft what's called a litigation hold letter. And actually, there should be lots of them. But there needs to be an initial letter. The initial letter should have a description of all of the information, documents, data to be preserved, a time frame for preservation. So I need the last 3 years worth of things, or I need the last 5 years worth of things. The categories of data to be preserved should list out the consequences for failing to preserve, and I mean in detail. Like, don't just say it's bad or the court will sanction us, but list, this could result in a default judgment. This could result in an adverse jury instruction. Explain what that means. Things like that. You should include a requirement to certify compliance. So remember, document, document, document. Part of that is documenting that your client received the litigation hold letter. And that's a corporate client or an individual client certifying compliance. There should be a prohibition in the letter on segregating or transferring data so that it's altered. So sometimes what people will do is they'll say, oh, okay, I'm supposed to save all this data. I'm going to take it off my computer and I'm going to put it on a CD. Well, the act of transferring it from the computer to the CD changes the data. Remember the metadata discussion? That changes it. So you need to prohibit segregating or transferring of data. Suspension of clean-out or janitor programs. A lot of programs have what they call janitor functions. So every 30 days it gets rid of all the emails. Or every 30 days it gets rid of all the deleted emails. Every day it'll get rid of deleted emails. Something like that. Almost all of those programs have settings, so you can determine how long that information is kept. They need to know that they need to shut those things off. No more deleting of anything. You may need to update and resend your litigation hold letter as the case progresses. Because what was relevant on day 1 of litigation is not necessarily what's relevant 3 months in, or 6 months in, or a year in, or, God forbid, 3-4 years in. So make sure that you're updating your litigation hold letter and resending it as often as you need to define the scope, the time frame, all of those issues. Warning. Litigation hold letters may not be privileged. Yes, it is an attorney-client communication, but in many cases, courts have determined that if there is a spoliation risk, there's an allegation that your client destroyed evidence, and then maybe proof that your client destroyed evidence, the court needs to look at what you as the lawyer communicated to the client as what to hold on to. And was that information that was destroyed within the scope of the litigation hold that you instituted on the client? And therefore, the court's going to look at that litigation hold letter. So, include your litigation hold letter on your privilege log. Also, please refrain from referring to anything that is privileged in the letter. So don't include the litigation hold as part of your case analysis, for example. Don't evaluate evidence. Don't evaluate claims or defenses. Don't talk about the substance of the case in the litigation hold letter. Have a separate document that says, here's what we need to preserve, here's why we need to preserve it, here's what's going to happen if we don't. These are the key people, these are the key sources, this is the scope of information. General cases, who do you send the letter to? Well, if it's an individual client, obviously you send it to the individual. But if you have a corporate or an organizational client, it's a little bit more difficult. The client's view is going to be to send it to one person, because we don't want our employees or our shareholders or our board of directors knowing that we got sued. And so we want that letter to go to one person, and that one person will be responsible for defining the scope of preservation and actually collecting the documents. Now, the attorney's view, because you are equally subject to sanctions, and in reality probably more likely to be sanctioned for e-discovery violations than your client is, your view should be to send it to as many people as possible. Let's send it to everybody. I don't care if you've got a company with 500 people, let's send it to every single warm body that you've got. You have to find a ground between those two things. So, at a minimum, if your client has something like an IT department, you should be sending it to the IT people, because they are the ones who know about electronic information. Or anybody who's a data custodian. Also, key witnesses. All key witnesses should get a copy of the preservation letter. Do not rely on a single contact person. I have been involved in cases, not on my side, but on the other side, where the key person who did the preservation of evidence actually ended up being a witness and had a motivation to destroy evidence. And I had a really fun time picking apart that attorney for just having one person in charge of a data collection. Keep a master list with the names and contact information for all of the recipients, the date and even the time and means of transmission. So did I fax it, did I email it, did I hand deliver it? When and how each recipient certified compliance, and what data each recipient potentially possesses. Why are we making this list? Because we are documenting. We are going to be able to show the court that we put in place a great litigation hold, and that the fact that evidence was destroyed was not our fault as an attorney. Do we want to take a break now or in a bit? Hands for now. All right, there are a few hands. We'll take 10 minutes. So it's 9:10, come back 9:20-ish.